Let's return now to the pardoning of Kathleen Folbigg and take a deeper look at some of the legal aspects of the case. Dr Robert Moles is a leading expert in miscarriages of justice. He gave evidence to the second inquiry into Kathleen Folbigg's convictions, which has seen her pardoned, and we're delighted to say he joins us now from Malaysia. It's terrific to have you on the program. You are Australia's foremost expert, really, in miscarriages of justice. Where does the case of Kathleen Folbigg sit within miscarriages of justices in Australia?
Well, it's clearly one of the most disastrous cases that we've had in Australia. The fact is that, in fact, Miss Folbigg should never have been convicted in the first place. There's very clear evidence given at trial to say that the forensic pathologists at trial didn't know what the cause of death was. And the only reason she was convicted was because there were 4 deaths. And they assumed that with 4 deaths, the only possible explanation could be that they were caused by third-party intervention, being the mother. That was simply incorrect.
It was really entirely circumstantial, and her diaries also played an important role in her conviction. But if you look on them through a different lens, the lens of a grieving mother, they could be read entirely in a different way.
Yes, the common sense reading of the diaries simply indicates that we've got a mother who'd actually lost 4 babies, an indescribable grief, and it's hardly surprising that she would make statements in the diaries about she felt responsible in some way for the babies' deaths. It's perfectly understandable. That's now been accepted, but that should have been the position all along.
People have made some parallels with the case of Lindy Chamberlain. Do you see parallels?
Well, of course. I mean, we have a situation in which the mother of a child or several children who have died has been unfairly labelled or categorised as an unfeeling person, and without any particular evidence to support it, has been held responsible for the deaths of the babies. It's perfectly clear that she should never have been convicted in the first place, and that these proceedings have taken far too long to arrive at the fairly obvious result, which is that she's not responsible for the deaths.
Let's talk about the amount of time that it has actually taken for this to happen, because it did take some time for the scientific discoveries, that DNA evidence, to actually come to light. But you are critical of the entire time that it's taken. At what point do you think this should have been reviewed, this conviction?
Well, certainly when Professor Cordner and Dr Hilton came forward at the beginning of the second inquiry and said that they were satisfied that there were actually explanations, natural cause explanations for the deaths of 2 of the children, that should have been a sufficient basis on which the conviction should have been set aside. When the 150 experts then signed up to a statement saying that they understood that there was a genetic cause of death, you see, all you have to do on a criminal appeal is to establish that there is either a doubt about the conviction, or that if the jury had been in possession of this new information, they might have come to a different verdict. Well, with 150 experts all saying that the evidence presented at the trial was incorrect and that there is in fact a DNA explanation, I mean, that's an overwhelming case for the conviction to be set aside, and that should have happened at least 3 or 4 years ago.
What changes would you like to see to the New South Wales law system to make sure that this never happens again? Not just from the initial conviction, but also in reviewing the scientific evidence.
It's perfectly clear that the appeal system in New South Wales, in common with many of the other states and territories around Australia, is not really fit for purpose when considering what we call post-appeal reviews. That means a person's had a conviction, they've had an unsuccessful appeal, and then questions arise about the safety of the conviction. 4 or 5 states in Australia have already implemented the right to a second or further appeal, and that clearly should be done in New South Wales. There should be an inquiry into the use of expert evidence in criminal cases, because as in this case, expert evidence was given at the trial that ought not to have been admitted. And there clearly should be a criminal cases review commission, such as they have in the UK and New Zealand, and they're implementing one in Canada. So Australia is virtually the only country, similar country, that has no such mechanism for reviewing post-appeal cases.
And just briefly, Dr Moles, Lindy Chamberlain got $1.3 million in compensation when she served 3 years for the death of her daughter. We're not there yet, but when we get to the point where Kathleen Folbigg should be able to seek compensation if her convictions are quashed, do you have any sort of idea how much she might be entitled to?
Well, a good guide would be to look at the case of Henry Keogh in South Australia. He was imprisoned for a similar period of time as Miss Folbigg, 20 years, and after he had his conviction overturned, it being understood that the crime for which he was convicted never occurred, he was given an ex gratia payment of around $2.5 million. In the case of David Eastman in the ACT, he was wrongly convicted for a similar period of time, about 20 years, and he undertook legal proceedings for compensation, and he was awarded over $7 million. So, given the similarity in the periods of time, an obvious calculation would be something between $2.5 and $7 million for Ms. Folbigg.
OK, well, we're a few steps away from that. It's great to get your perspective this morning, Dr Robert Moles. Thank you.
You're very welcome.